Good evening, everyone. Welcome to Jnanavarthini. I'm really excited today. We are having this privacy law quiz. As a student, I was an avid quizzer, and later on, I started enjoying creating quizzes. So I'm really excited, though I'm not allowed to answer questions today. So today's question is not to test your in-depth knowledge on privacy laws. It is more of a trivia quiz, and it is an opportunity to discuss some of the aspects of this laws.
Absolutely.
And not just that, there is a cash prize which will be announced at the end of the event by Mr. Ramesh. So I invite Mr. Ramesh to take over and start this quiz. Thank
Great.
you.
Thank you very much, Manju. Warm welcome to all of you. As she said, the context, be with me, all of you, that participation is the key. And each question, there are only 14 or 15 we are talking about. And just to initiate the discussion is the what we are looking at it. For example, if you're talking about, let's say, data portability. Now, how it is being viewed from the GDPR context or whatever comes to your mind with the case study, with the example. So let's have that interaction to build the concepts and strengthen our concepts, what we know. That's the idea. And obviously, she said we will also try to give you the spot award, whoever participates and answers. So don't worry about the outcome. Let's participate. Thank you. Let's go ahead. Now, what I will do is that I will put the question. I will read the question, try to understand, and then select whichever comes to your mind, and you can quickly put it in the chat window. To start with, which was the first country to adopt a data protection law? Germany, Sweden, Singapore, Norway. So we will have our own time, let's say for each question 2 minutes to understand, and then you can quickly put it in the chat window, whatever the answer comes to your mind. So I'm also tracking the time, so I will tell you guys once when you are ready. So I could see chat window is getting filled up. So don't worry about the right or wrong answer. Absolutely go ahead. The participation is the key. Okay. So I could see, please participate, all of you. Okay. Okay. Okay, great. I think
if there are multiple correct answers, will you give weightage to the first correct answer?
Yeah.
Okay. Okay. So that people
because
will
answer. Yes.
quickly. Otherwise, they will be waiting for somebody else to post, and then they will be.
Yes. Absolutely, sir. Absolutely.
Okay.
Great. So I'm going to see that. Just give me a minute. So the correct answer is A, where in the year 1970, the federal state of Hesse passed the first national data protection law, which also the first data protection law in the world, 1970. In 71, the first draft bill was submitted for the Federal Data Protection Act, federal at the national level, European. And finally, on 1st January 1978, the Data Protection Act came into force. So whoever had said A, Germany, I could see one. Anyway, Manju would have recorded it. Congrats. And Singapore, if I'm right. Anybody remember when it came in? If I'm right, anybody? 2000?
2012, I think.
Absolutely. Thank you very much. That's exactly. I know you conducted that session, Anand sir. Singapore came into PDPA, Personal Data Protection Act of Singapore, came into force in 2012. Okay. But anyway, as we all know, European guys, especially, right? This Germany, Sweden, Norway, these guys played a vital role, and Germany, Hesse was the first state. Let's move ahead. 2. Which is the first country to earn an adequacy decision status from the European Commission, EC after the GDPR came into force. We all know, right? As on date, around 12 to 13 countries have got the adequacy status, including the latest one, if my memory is right, South Korea. We are talking about which is the first country which can go, approved by EC as an adequacy. Japan, Brazil, New Zealand, South Korea. Just think about it, and like a previous one, you can put it in the chat window. I will also have a look at it. Sorry. Okay.
Ramesh, you have to be careful. You should not give away the hints.
Yes, sir. I understand. You are giving a hint that I had already given a hint here.
Yeah.
I understood. Got it. All right. Superb. I could see. Shall we? All of you tried. All of you had chat. Put it in the chat. Please participate. Don't worry about right or wrong answer. All right. Okay. The answer is Japan. We all know. On 23rd January 2019. And when GDPR came into force? Anybody?
May 2018, 25th May. This is basic.
Excellent. 25th May 2018.
18.
Excellent. So we are talking about almost within a year, 6 months, 8 months. On 23rd January 2019, the safe and smooth trans-border transfer of personal data was realized between Japan and the European Union, the first country to go. This mutual adequacy decision was the first in the world, and Japan was the first to be certified under Article 45. I'm sure all of us very clear. By the way, if I can ask, check your memory. How many of you remember how many articles are there in GDPR?
99.
Oh, so nice, so nice. Thank you.
Yeah.
Article 1 to 99. Beautiful. Even the erstwhile PDPB of India, if you remember, right? They also had the same kind of a concept. Of course, in the upgraded or the latest bill, it has been changed. Otherwise, that 1 to 99 is the famous one. And we had gone through all the 99 articles in a very, very detailed way as part of our, right? And many of the articles related to administrative powers, administrative, fines, etc. But mainly the articles, one related to the data principal rights, 2, data controller and processors obligations, 3, data protection impact assessment, 4, the role of the DPO. So in my opinion, almost around 50% out of that 99 articles played a vital role with respect to GDPR. All right. Whoever had answered, I had noted down at least a few names. Many of you had answered correctly, Japan. And South Korea is the latest one, if I'm right. Navi sir, on this, can I request you to share your thoughts with this is the question is not related to the trans-border certificate or adequacy part. I want you to share that latest on certification of GDPR, okay? Because there is a question that already in people's mind, whether that article 42, 43, 44, if I'm right, which talks about the certification, whether European Commission has identified, 1, the things related to certification, 2, have they recognized any body who can perform a certification for GDPR, sir? Any idea? Latest one? Navi sir?
No, I think France has provided certification to one agency.
Okay.
When I last searched, that was the only one I was able to identify. I didn't see any other organization. That we are talking of again agency other than the the supervisory authority who can provide a kind of assurance certificate. Am I correct? That's what you are talking
Yes.
about.
Huh? Yes. It's like a typical management certification by recognized body, right? Otherwise, as on
we wanted to actually make FDPPI one such certifying authority, at least in India. Okay.
Right.
But actually, we can even apply for the GDPR certification, provided you have a local body there to support you. Because I think it will ultimately be provided only to the local organization, not to an international organization. But if it works out, if you have a framework, based on the framework, and if it covers all aspects of GDPR, if a proper report is made like that, then perhaps with the assistance of a local agency, like in the Gulf, we can take the assistance of this somebody there, one of our supporting members or something, or in UK, our Kamal Acharya kind of this thing, that can be tried. Okay.
Sure. Great. Thanks, sir. Actually, Subrahid sir, even I'm still checking, okay, with my counterparts in Germany. As far as I know, as on date, except France, what Navi sir quoted, nobody has got the kind of certification seal. Yet.
Oh, okay.
Okay, thank you. I'll come back to you in case if I'm successful to all of you.
Okay. Sure.
Ramesh sir,
Good.
there was one body, right, that recently got that recognition of being a certifying body under that article. I'm just missing out on the name. I'm not
I
remembering
had
the
seen
name.
the France that CNIL had
Correct.
registered somebody. Okay.
Yes, some privacy, something like that is the name. I missed out on that.
And they have actually published a standard on certification. I don't know whether I am only talking of the standard or whether anybody has been approved. Maybe it can be looked at. But France is the only country which I think has made some progress on that aspect. Okay.
Check, Sarnyakita, in case if you are successful, you can share it. I will also try. I am trying. In fact, I'm checking with my counterparts in Germany because they will know. We will come back. Okay. Thank you. All right. Question 3. Which of the following are added as the data subject rights in the latest bill of India, Digital Personal Data Protection Bill? I'm sure all of us, Navi sir, covered this on that very day it was released. Compared to the previous version, rights of grievance addressal, right to nominate, right to be forgotten, or A and B, or all the three. I know very difficult for us to remember, but just to try, what is the latest addition in the latest bill 2022? All of you put your things in chat window. Okay, beautiful. I could see 7 answers already. Okay. Anybody want to unmute and then answer? Just unmute yourself and then please try. The statements both A and B. The data principal shall have the right to nominate in such a manner as may be prescribed any other individual, that is nominating, right, who shall, in the event of death or incapacity of the data principal is the terminology used in our bill, equivalent to data subject of our GDPR, exercise the rights of the data principal in accordance with the provisions of this act. For the purpose of the section, incapacity means inability to exercise the rights of the data principal under the provisions of this act due to unsoundness of mind or body. So both the statements A and B have been added as new elements: right to nominate and right of grievance redressal. Navi sir, are you comfortable with this answer, both A and B, sir, or you have difference?
No, it's okay. But you said which is the latest one? The latest one, of course, nomination, because nomination was, I think it was suggested by the Joint Parliamentary Committee. Grievance redressal has been there from some time. So Out of the two, if a distinction has to be made, you can say
B.
navigation is the latest, but A and D is okay.
Right, very good. So the reason I'm asked Navi sir is if somebody had answered B only, that's also a right answer is what I'm trying to say. Thank you. Thanks, Navi sir.
Okay.
We will take that way. Manju, make a note of this, okay? Because I realized it, there could be a kind of, okay. We'll move ahead. Question number 4. Which is the first country in the world to protect neuro rights? I wanted to make it a little bit simple so that if you would have attended the last quiz maybe 3-4 months back, I am giving a clue. This was also part of, this question was part of that. Because this is the first, neuro rights as a new thing which had come in. And if you remember, Navi sir brought in the external speaker from US on this during our IDPS, and Navi sir also had given lots of blogs and materials on this neuro rights. That's why we wanted to keep this question alive in our mind. And I'm sure all of you are following Navi sir in Telegram, where he has given so many articles about neuro rights, and he wanted to form a group also, subcommittee kind of, task force within our FDPPI. So I'm sure most of you would have answered. Can anybody quickly tell me, unmute and tell me which is the country?
Chile.
Thank you very much. The answer is 3, Chile. Neuro rights include.
I also remember from our IDPS thing, Chile.
Yes. That's why, because it's a new topic and we are doing lots of R&D on this, I thought we will retain this question, myself and Manju. That's why we retained it. Neuro rights, when we talk about it, it includes the right to mental privacy, personal identity, the free will of thought, equitable access to the technologies which increase the human capacities, and protection against discrimination. An excellent new area which is coming up. All right, thank you very much, whoever has participated. Moving on. Article 17 of the GDPR refers to the which data subject right? I know it is a tough question to remember. Data subject rights, right? Starting from right to be informed, our privacy, notice and consent, etc. All these things. Just try if you still remember. Right of access, right to rectification, right to erasure, also known as right to be forgotten, and right to data portability, which is the article which it talks about. 17 refers to which right? Have you participated in the chat window? By the way, anybody remember how many rights are there for a data subject aspect of GDPR?
It's 7.
7
Wow.
principles are there, but rights, how many? Even 7 principles, and rights are more, I suppose, is that or lesser?
I think 12, if my count is right.
Need to Google that now. We have to check that out. Ramesh is really pulling our brains out today. Huh?
Just try. Because see, like this 1 or 2, we will remember institutionalized in our mind. That's my idea. Anyagita, really, I appreciate you to start with what you said, 7 principles, right? Including the 7th one is accountability by the data controller and processor organizations, correct? And very good. Right. Anybody? How many rights are there? Just check and let us know. No, I have it in front of my screen, but I want you guys to tell me. Okay. To come back here, Article 17 talks about right to erasure or right to be forgotten. Correct. Very interesting right. The data subject shall have the right to obtain from the controller the erasure of his or her personal data concerning him or her without undue delay, and the controller shall have the obligation to erase the personal data without undue delay where one of the following grounds applies. Obviously, there is a criteria associated. So there are 1, 2, 3, 4, 5 as part of that article and recital. If you go, this beautifully explained. Or not to quickly tell, the purpose is done. So you can ask them to take it out. Or your data has been processed by the controller against the purpose for which you are given consent, obviously you have the right to take it back, erase it, etc. Right? We are aware. Anybody check the Google and then tell me how many rights of the data subject?
8.
Six,
8,
sir.
8 under GDPR, right?
Excellent.
Hey, I'm getting 6.
You hitting 6 is that?
I think,
Subrahim,
okay.
I
Google
think
is giving us different answers. Huh?
right to object and right for
Data
Automated
processing.
decision making.
decision making, I think that is not included in the first 6. Is it not?
Okay.
So basically, there are right to access, right to rectification, erasure is one. Then right to restrict processing, portability, object
Yeah.
decision making. So that's why it's 6 coming. But yeah, in that they have split in. That's why it looks
There
like
is
8.
There is no right
Yeah,
to
I'm getting
notification.
one
There
is
is no
right
there is
to
no right to grievance redressal.
Ha, right.
there's a true word set that has come. Right to access data, Article 15 is one.
Ha.
The right to have data transferred, Article 22.
Hmm.
Right to have data rectified, Article 26, third. Right to object to processing, Article 21, fourth. Right to have data erased, Article 17, 5.
Four.
Right to restrict processing, Article 18, 6. This is what this fellow is drawn up.
Hmm.
Okay,
6.
I will help you. Maybe at the
Okay.
end I will share my screen.
Yeah.
Okay. Manju would have taken note of that word answer. Next question related to Information Technology Act 2000/2018. Which section in ITA 2008 talks about sensitive personal data, sensitive personal information? 43 capital A
43A.
or section 42? Okay. 44 capital B or 45 capital A? Question number 6. Anybody? I think you would have answered in the chat window. I remember, I will never forget this answer in my life, thanks to Mr. Navi. He used to say when he conducts the training, 43 capital A, the capital A, he will give that to Pagi. I remember.
I was just trying to point out that 43 small a is a different
I know.
section. 43 capital A is a different section.
There you are. That's what I'm saying.
Ah.
I attended your sessions. I was really, why he's saying, why? Then I realized it. Oh, this is the reason that 43 capital A and 43 small a, that bullet is different here. Very good.
Yeah.
The 43A, compensation for failure to protect the data, thanks to Subrahim, that this is the updated in the ITA 2008, where a body corporate, which refers to the organization, which is processing or dealing or handling any sensitive personal data or information in a computer resource, which it owns, controls, operates, if it's negligent in implementing and maintaining double quote reasonable security practices and procedures, we all know, right, RSP, and thereby causing a wrongful loss or wrongful gain to any person, such a body, corporate organization, shall be liable to pay the damages by way of compensation to the person so affected. So this is the first time, I think, where the liability or the fine had come in, that, you know, in our law through this updation of the section 43 capital A of Information Technology Act 2008. And of course, the explanation provided, what do you mean by sensitive personal data, right? The definition exists. And we all know, right, what is the bare minimum we are talking about in implementing and maintaining a reasonable security practices in terms of any of the technical controls, what we talk about. That's where your ISO 27114 controls comes into picture, starting from, you know, whether encryption to authorization to authentication to access control to whatnot, backup to restoration and so on. Very good. I'm sure many of you would have answered rightly. Move ahead to the next question, question number 7. Which is the first state in the US to have a modern privacy law? I'm sure many of us are tracking, right? Oh God, now almost every week or every month, 1 or 2 states comes out with it. I used to, whenever at least I alert comes to me as part of that data guardian, immediately I put it in our group also. Lots of states, right? California, Virginia, Colorado, Connecticut, now so many, New York, etc. And then privacy law with respect to AI also coming up plenty. Coming back to this question, any idea which is the first state in USA to come out with a privacy law, a state level law we are talking about? I'm sure many of you would be having a quick, good input here. Yeah, Navi sir has told me not to give any hint. I'll stop here because because we all know. Yeah. All right. Anybody? Just unmute and then you can answer. No problem. I think we all know, right? California, which called as earlier version, the first version came in 2018. California Consumer Privacy Act. I think I am extremely happy to share. Many of us know that we had a kind of very detailed discussion. I remember that time Anand sir used to conduct PDPA Singapore version. I used to conduct this California Consumer Privacy Act, which is the first one, granting the California residents increased transparency and the control on their data, right? How it has been collected and used by the businesses or the organizations. We also talked about very confidently that time, if you remember, opt-in and opt-out and sale of personal data. All these things need to be obligations of the data controller or the organizations. Subsequently, this California Consumer Privacy Act has been renamed as the CPRA, stands for California Privacy Regulation Act, and which came up recently, right? From January 1st, 2023, it is being implemented with a look back to January 2022. The data, at least 1 year data they are talking about. And the CPRA, California Privacy Regulation Act, has established, like Data Protection Authority of India, what we are talking about, the same way California Privacy Protection Agency, CPPA, to implement and enforce the law, like our supervised authorities in European Union, the states, right? And the Attorney General also retains the Civil Enforcement Authority. In fact, we had the upgraded discussion also in our Jnanavardhini, one of the session I remember, on CPRA. Now there are lots and lots of laws that come up. As far as I remember, almost 15 states in the US had come up. And I'm sure most of us know in the call, US is also working out a federal privacy law, right? Apart from this, that is not yet, still it is in progress stage as far as I remember. But otherwise, Virginia, Colorado, Connecticut, New York, Michigan, so many states have come out with its own laws. Whatever I know, little that there is the kind of almost the same in terms of the concept and in terms of the expectations of the organizations and so on. Quite interesting. All right, moving on to question 8. Which statement is true about the Singapore PDPA? Anand sir, really to you that I really want to check your memory now. Yeah. Look at this.
My memory.
Look at this.
Let me see. Let me give a try.
So you can. Applicable for living and deceased individuals. Applicable for deceased individuals only for a period of 10 years. Not applicable for personal data older than 100 years. Which is the correct statement as far as, and before we please try your answers, chat window. In the meantime, we have discussed in a very detailed way the Singapore PDPA. I think in whatever
Actually,
law
I think
we
it
have
is D. All of the above. It's okay.
Okay.
Can we change our answers?
Yeah, go ahead. Anand sir, Subramanian sir is challenging you now. Yeah.
Okay.
Great. Okay.
I'm confused. I want to change the answer. I think it is ABC. This is I'm not sure. Anyway.
And I think in whatever the law, we had discussed it almost 10, 15 laws within our FDPPI community. I think this PDPA Singapore is the law, right, which we all know that it also applicable to the deceased individual. First time we talked about it. And if you remember that after the person ceased to exist, yeah, his or personal data need to be protected for 10 years, what we talked about. I think I am almost given a clue. And I will go with Mr. Subraidu. That answer is not applicable for personal data older than 100 years also is true.
Yes.
So Singapore, the Personal Data Protection Act, PDPA Singapore provides a baseline standard of protection for personal data in Singapore. It complements the sector-specific legislative and regulatory frameworks such as the Banking Act and Insurance Act. Quite interesting. It comprises various requirements governing. We used to call, if you remember, CUD, collecting the data from the data subject. How are you use, and how are you disclosing it to the third party or whomever? So CUD.
Ramesh,
And
sir,
care of,
I'll apply examination logic here, right?
yeah.
I know for sure that 10 years is correct. Okay. And
Yeah.
if B is right, A must also be correct. Right?
Yeah.
And
Yes.
there is only one option out of the 4 which gives multiple. Okay. So it has to be D only. That logic I apply.
Great. And this look at the third bullet, quite interesting as part of the law. I don't think we had seen anywhere in whatever our discussions with other laws. It also provides the establishment of, at the national level, something called Do Not Call Registry, DNC. Individuals may register their Singapore telephone numbers with the DNC register to opt out of receiving any unwanted telemarketing messages across the organization. And if you are still getting it, you have the right to grievance cell, yeah, with the PDPA Commission, Personal Data Protection Commission, PDPC Singapore. And we talked about it that PDPC Singapore need to sit in Singapore, and his or her details need to be made available, contact details, etc., for the Singaporeans to contact him or her, like a DPO. For the act.
I have one observation regarding the Singapore law.
Yes, sir. Please.
Now it says that the personal data about a deceased individual who has been dead for more than 10 years is not applicable. Within 10 years, it's applicable. Okay. Now, if you want to apply this, you should also define this nomination aspect. Now, who is going to exercise the right? Because this second aspect, which is this 100 years criteria, is applicable for the data in terms of security. Okay. PDPA 2012 applies for data in terms of security up to 100 years. There is no reference to the individual. But this 10 years, I think it makes a reference to the deceased individual. Now, if there is a deceased individual, then somebody has to exercise the right. Now, in India, we have now adopted 100 years. Okay. We have not had these deceased individuals, but this nomination facility we have separately considered. I think Singapore has not specified, at least in this act, there is no mention about nomination, if I remember correct. I don't know whether there are other local laws from which it can be drawn. In India, I have stated that nomination is provided in the data protection law, but Information Technology Act says a nomination document, if it is exercised in electronic form, it will not have legal recognition. Therefore, we need to have a written nomination document. With that, this DPDPB 2022, when it becomes a law, you will have nomination facility. Okay. So there's a combination of a paper document and a provision in DPDPB bill which provides for nomination in India. Singapore, I don't remember to have seen the nomination. Anybody, do you remember anything about nomination in the Singapore law? I don't think so. Yes. Ramesh, yeah.
Even I don't think, sir. I don't think.
Yeah. I think it is an it's a omission there. Okay. If you want to give the right to the deceased data principals, then there has to be somebody who has to be representative of the deceased person.
Yes,
Okay.
yes, yes.
So it has to be through will or through a nomination document. I don't know how, maybe we have to interpret the Singapore law as possible only through a will, perhaps. Okay. Yeah.
We will check this, sir, actually, right? How the deceased person case is being handled through what provision? We need to really understand that. Yes,
Yeah.
at least.
Navi sir and
of-
Ramesh sir,
Yeah.
this DNC enforcement in India, right? I think that is a really
No, it is
need of
done
the
under,
hour.
no, it is done under TRAI as a part of the licensing obligation. It is not under data protection law, but it is under the TRAI.
No, but then what
That,
redressal? What redressal do individuals get is the question.
No, if you
Ah,
want to claim compensation,
Yeah.
you have our universal law called Information Technology Act, where you have to say some activity which is like impersonation or something like that has caused a damage to you in terms
So
of.
that is what, no, sir. I have to prove that I suffered a loss, right? I mean,
No,
the
say,
annoyance. The
if you
annoyance
want to
factor.
claim compensation under Information Technology Act, you have to bring the offense under Information Technology Act. So do not, if DNC is not followed, you can say it is like a spamming. So spamming means in some way causing inconvenience, harassment, and then reducing the utility of the system you have got or something like that. Okay, so section 66 has got diminishing the utility of the device. So you have to say that by even though another regulatory agency has registered a particular this thing for DNC, which means that there is a sort of a regulation to follow that. Somebody has violated that, and that violation has caused diminishing the utility of my computer system, which is a section 43, section 66 offense under Information Technology Act, and you can try to make a.
Now, sir, question here is, if this mechanism was a mechanism available before, let us say, Supreme Court judgment saying that, privacy is a fundamental right, right? Post the judgment which has said that, okay, no, privacy is a fundamental right, then, and the Supreme Court also asked government to formulate a law. Is it not a duty of the government to protect privacy under that law also? Why has that been left out if I were to question that? The fact that there might be some other provision somewhere else before the entire action was taken by the government post the Supreme Court judgment, that could be wiped out, right? Now that after the Supreme Court judgment, government has said, yes, privacy is a fundamental right, then by not including a provision to protect my privacy and protect myself from all this spamming and everything, can it not be argued that, my privacy right has not been properly fulfilled by whatever is the new law? And there's a gap and it needs to be incorporated here. Whatever existing earlier was before privacy being declared a fundamental right.
Say, it has to be brought under the permissions. That is, you have given your personal information to the mobile service provider for a specific use, prohibiting the use for unsolicited calls. So that is a violation of your permission. Your present privacy law, you can apply for that. Only thing is the data fiduciary here will be the ISP, not the person who has sent you the message. So you have to claim your compensation or.
No, Navi sir, the problem is there in the telephone connection application that I made, somewhere in the small print, non-compliant with the current consent requirements, there might be somewhere some clause which says that I'm only also giving consent to the telecom service provider to share my data with third parties and all, and he's gone ahead and shared that data with Bajaj Finance and HDFCs of the world.
No, that is old consent. Now, after the DPDPB 22 comes, one of the requirements is that there has to be a new consent.
Where was that, sir? I did not see that.
It is there. It is there. It is
Oh,
there.
okay.
That in case of existing this thing, consent will have to be obtained once again now with the
And now this new consent will have to be compliant with the new rules regarding
current law.
consent.
With the current law.
Okay.
And for them, this advertiser is like a processor. They are handing over this information to the data processor under certain permissions or for specific purpose. He should use it only for those purposes. Otherwise, that advertiser has an obligation to the data controller or the data fiduciary. I think that is how we may have to.
I don't know, but some people can do an experiment. In one case, for example, maybe 3-4 months ago, sir, the moment you make a part payment of a credit card bill, right? You immediately start getting SMSs and calls about personal loans.
Okay.
I don't know how many people noticed this correlation, right? And I read also somewhere that these fellows, they get this information that, okay, maybe this fellow got a credit card bill only because he's part paid it. Then there might be a requirement for a person and suddenly start getting calls and SMSs.
Yes.
So that is clear. I don't know how and why that data goes out. Is a potential leads.
Right now it is happening. There is no doubt data is being shared. Now, in the new act, these things will be permission based. And if you want to claim compensation, it will be harm based. You may have to say that such and such a harm was caused to me because harm has indicated gain and loss. No, both are there. Okay, when you define harm in the new act, it defines that a gain of a property which is or a wrongful loss of a property is a harm which is recognized. So there is a provision, but you have to make a claim that this person by sending this spam message has caused a loss. Now, how do you quantify that loss is an issue which you need to think about.
Don't we see that instead of going about it in a very roundabout way, there must be a direct, explicit thing as these guys have put it in their law?
Yeah,
I'm sure this is business interests have prevented from putting this kind of clause, a stringent clause like that in our law.
No, it can come in the form of a notification, one para notification from the Data Protection Board also in future. It's not necessary that it has to be brought as a section here, but it can come as a notification also.
Maybe FDPP can take the lead here, is what I would say.
Can. Yes.
Yeah.
We can provide our views to the Data Protection Board at the appropriate time. Okay.
Right. Great. So shall we go ahead, Subrayati sir? We will come back immediately.
Yes.
We will discuss it. Thank you. Thanks, Navi. Because already we are running out of time. Which country or state has proposed the Artificial Intelligence Act? Which country, first country or state has proposed the AI Act, which is totally a new area? European Union, Connecticut US, or UAE, or Brazil? Quickly give your answers in the chat window, please. I'm seeing lots of people are not giving in the chat. Yeah, one is up now. Any idea? As usual, right? The Artificial Intelligence Act is the regulation proposed on 21st April 2021 by EC, European Commission, with the aim to introduce a common regulatory and legal framework for AI. The scope encompasses all the sectors except for military and to all types of AI. It's a new topic per se. Lots of things are emerging, processes. Lots of countries are also working on the AI Act. I think the day before yesterday also I saw one country. AI Privacy Act they are talking about. I will recall and share it in the team. Okay. Moving ahead. Next question, question 10.
What is the answer? Did you give the answer?
Yeah.
Which one? Yeah.
Union.
Okay, that is, they have proposed it. It is still not passed. They have proposed. Okay.
Yes. The question also proposed only.
Yeah, I saw that.
Yes, sir. I was worried whether I had said that whether it is already. All right. The first GCC member state to issue a generally applicable data protection law. In the Middle East, we are talking about Gulf Cooperation, seven states, right? GCC, Qatar, UAE, Oman, or Kuwait. Which is the country which had come with its own law? Any idea? Just please participate. Okay. I will go ahead with the answer. Qatar had adapted its data protection law in 2016, subsequently Bahrain 2018, UAE published in 2021. I think DIFL law, right, sir? Dubai law. And Saudi Arabia published its in 2021, Oman, Muscat law in 2022, and Kuwait is not yet, they don't have any laws as on date. Moving ahead, in the Digital Personal Data Protection Bill of 2022, India, our bill we are talking, there is a penalty of up to rupees 10,000 for a non-compliance with the section 16. I know it's a tough question. Section 16 refers to what? We are talking about duties of the data principle, right? That means you and me need to be aware of our own duties, and just to touch upon what are our duties as per the bill. A data principle shall comply with the provisions of all applicable laws while accessing their rights under the provisions. A data principle shall not register a false or a grievance or a complaint with the data fiduciary or the board, obviously. A data principle shall, under no circumstances, including while applying for any document, service, unique identifier, proof of identity, or proof of address, furnish any false information. A data principle shall furnish only such information as is verifiably authentic while exercising the right to correction or erasure under the provisions of this Act. Very simple, right? We need to be aware of our own principles, our own what we need to adhere to. So that is what section 16 talks about. Question number 12.
Ramesh, the last question you didn't give time for them to answer actually.
I thought that's why I gave a benefit of doubt to them. Tough question.
Because there were no options. So probably I thought they were also waiting for the options probably. Okay,
no, actually, trust me, I thought it will be difficult, right? If I ask which article, Papa, okay. No problem. This question can be taken out from our examination.
Yeah.
okay. No, the clue
Not
was it was only rupees
there's not
10,000.
multiple choice, Ramesh sir.
Yes,
No,
yes.
the clue is it's only 10,000. So you wouldn't find an organization with 10,000. So it has to be something.
Yeah. Correct. Now, I really thought, okay, let me not put them that side with, okay, great.
Okay, then it's fine.
Question number 12. In a situation where the data principle voluntarily provides the personal data to the data fiduciary and it's reasonably expected that they provide such personal data, etc., etc. What is this referred to as in our bill India? Please read it. There is a clue there. If I have to say, take Manju's previous one. In a situation where the data principle voluntarily provides the personal data, what is being referred to us in our bill is the question. Any idea? Any guess?
Related to do with consent management, consent manager?
Excellent. Deemed consent, right? Voluntarily providing.
Okay.
Right? Where the data principle voluntarily provides the personal data to the data fiduciary. Voluntarily. There is no kind of, So we all know, right? Deemed consent, explicit consent. Explicit consent, making them aware and having a kind of evidence that you have taken it from them with the signature or. So the deemed consent is part of the section 8 of the proposed bill, which sets out the situations where the consent of the data principle for processing the data is assumed and does not need to be explicitly sought from them. The provision for the deemed consent under the bill provides for wide-ranging circumstances for processing. What is processing? Storage, collection, and processing of an individual data without their consent. This could potentially lead to the violation of one's right to privacy, obviously. So this is where both the parties need to be very clear, right? Organizations also need to be very clear, not to take this Section 8 into their advantage, vice versa. So there need to be a proper kind of policy or the framework in place by the organizations, data fiduciary organizations. Obviously, we say, right, whether if you are handling a sensitive or critical data, try to have the kind of explicit consent. I think here also, because it's new, so we went ahead. Oh, question number 13. Sort the countries in the order of implementing the personal data protections, the earliest first. Basically, we are looking at which are all the, what is the chronologically order by when these countries had enacted the law. At least we know, we discussed it to give you the clue. Singapore, we talked about 2012. EU, we talked about 2018. And you have any idea about Morocco or China is the question. Which had come first, etc. You may try, please. I think question is clear, right? Just try.
Your question.
Okay. Okay. I could see somebody is participating, Manju, so no issues. 61, very good. All right, let's see. Morocco's 2009 relating to the protection of individuals with regard to the processing of personal data, and its implementation started way back in May 21st, 2009. Singapore, we talked about it, October 15th, 2012. PDPA of Singapore, 2012. GDPR, we are all very well aware, as Mr. Subrayadu correctly said, 25th May 2018. And we are talking about China PIPL, right? The first comprehensive national level personal information protection law, PIPL, came into effect in 2021, November 1st. So this is the order. Just to get that. I think this is the last question. Which judgment is considered as the turning point? I want to conclude it in a very, very positive and energetic way. So I know all of you will be knowing this answer. Which judgment is considered as the turning point in the evolution of the concept of privacy in India? Somebody can unmute and tell me, please. Which is the judgment, which is the case which really led into making the privacy or, as the fundamental right, and subsequently Supreme Court asking the government to come out its own law. Anybody? Justice K. Puttaswamy case 2017. We all know right to privacy verdict, officially known as Justice K. S. Puttaswamy case, as a landmark decision of the Supreme Court of India, which holds that the right to privacy is protected as a fundamental right under Articles 14, 19, and 21 of the Constitution of India. I think this is the questions we had. Before I really close this, I just wanted to give the...
Ramesh, what was
yes,
the
sir.
role of Justice Puttaswamy in this case?
What is the
role of Justice Puttaswamy in this case?
Nice question. That is the background, sir, that
No.
Aadhar's...
No, he was the petitioner.
Correct. Aadhar case, right?
When we say justice, normally we confuse it.
Oh, okay. It is not that he has delivered it.
Yeah.
You are right. Very good. Sir, you can elaborate it more for our benefit. I understand your question now.
No,
so basically, he is the petitioner, which he had come out against that Aadhar card, if I'm right. That is where it started, right?
Correct.
From Karnataka.
Yeah, from Karnataka. Yeah.
Yes.
Right. Just made a point.
Yes. And I think who said that rights of data subjects in GDPR 088 rights? Who said? Absolutely correct one. Starting with the right to be informed, Article 12, 13, 14, right to access the data, Article 15, right to rectification, Article 16, right to erasure or right to be forgotten, Article 17, and right to restriction of processing, Article 18, right to data portability, Article 20, right to object is Article 21, and last one is right to object automated individual decision making, Article 22. So the Articles 12 to Article 22 talks about rights of the data subjects in GDPR. Fair enough. I think with this, we are through with the question. Hope it was a good discussion and really some kind of reorientation of our thoughts, if I'm right. Yeah.
Ramesh, it was actually
yes.
an excellent session, and it gave us a thought that we have to read back to our lessons that we have left behind, because there was lots of brushing up that is required after the question is popping up, realizing that okay, we don't remember it now. Probably 2-3 years back when we started, 4
Yes,
years back,
yes.
we might have been read it or learned it. Now the
Okay.
brushing up is really needed.
Now,
Yes, yes.